And this thing went super poorly for the prosecutor, not just according to people who are sort of watching the trial, but according to the judge. So the prosecutor, I don't know how disbarment is not considered here. Seriously, the prosecutor twice essentially got called on the carpet by the judge, who was very, very pissed off, and for good reason. And the reason that the judge was pissed off is in the first instance, the lawyer attempted to make the argument during cross-examination about why he had remained silent after his arrest. So when he was arrested, he didn't talk to the police. Now, it is a well-established rule. I mean, literally going back centuries, that silence is not an admission of guilt. Okay, this goes all the way back to like the Thomas More trial. The belief that if you are silent on a particular topic, this means that you are guilty, as well as the notion that if you take the Fifth Amendment, that this is an implication of guilt in a courtroom, you're not allowed to even bring that up if you're a lawyer in a courtroom. You're not allowed to. Okay, that's like black letter again, first-year law. And the judge just reams the prosecutor for attempting to do that. I mean, the prosecutor did that. He's like, you're really attempting to make the argument that Kyle Rittenhouse not talking to the cops means that he's guilty? Like, by the way, again, quick lawyer rule, guys. If you are ever arrested for a crime, call your lawyer and say nothing to the cops. If you're ever arrested for a crime, call your lawyer and say nothing to the cops. This is, again, first-year basic law. Okay, and it doesn't mean you're guilty. It means that you need to talk to your lawyer because the police are there to do their job, and that job might involve asking questions that implicate you in crimes you didn't commit, for example. So you always want to work with your lawyer. Okay, but one thing that's not allowed to happen is in the courtroom, the opposing lawyer isn't allowed to say, because you didn't talk to the cops, this means you're guilty. That gets rid of the purpose of the Fifth Amendment in the first place. Here's the prosecutor just getting reamed by the judge for this one.
I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that. I said I had heard nothing in this trial to change any of my rulings. So why?
Testimony, Your Honor.
Pardon me?
That was before the defense testimony.
Don't get brazen with me. You're an experienced trial attorney, and you're telling me that when the judge says, I'm excluding this, you just to take it upon yourself to put it in because you think that you've found a way around it? Come on.
Okay, and then the judge says, I don't believe that you're acting in good faith. Okay, the second thing he's commenting on there is that there was a piece of evidence that was ruled out pre-trial. Okay, that piece of evidence has nothing to do with the case. It comes from like a month after Kyle Rittenhouse got out on bail. So you're talking about months after the initial incident. And he was photographed in a bar with members of the Proud Boys wearing a shirt that said free as F. Okay, that is not relevant to his state of mind on the day that he shot people. That is not relevant. Okay, that was declared out of evidence by the judge because when it comes to criminal trials, you have to weigh prejudicial evidence against the probative value of the evidence. What that means is that, for example, in a criminal trial, you're generally not allowed to bring up the criminal history of the person who is on trial because that does not go into the calculation as to whether the person committed this particular crime. So if something happens 3 months after an incident in which you're wearing a shirt that's offensive and stupid, does that have anything to do with whether you committed the particular crime that is in question 3 months earlier? The answer, of course, is no. It does not. And the judge had already ruled that out. He'd already said, I'm ruling that out. If you want to approach me later and ask about it, you can, but it's out for now. Right? I'll leave the door open to myself, but not to you. This prosecutor just started bringing up the evidence that had already essentially been ruled out in the first place. And the judge is like, you can't do that. I know what you're doing here. I mean, this prompted, by the way, the defense to ask for a mistrial without the ability of refiling. Right? A mistrial with prejudice, saying, just to end the case right now. By the way, I wouldn't be surprised if this trial never goes to the jury. That's how bad this is. He says the judge just went after him. And then, according to the Associated Press, the defense asked for a mistrial over what appeared to be an out-of-bounds question asked of Rittenhouse by the chief prosecutor. The judge should not immediately rule on the request. The judge did say that the kind of activity that the prosecutor engaged in here essentially was bordering on mistrial. It was certainly grounds for an appeal if Rittenhouse were to be convicted. It's so weak. How weak was the prosecution's case? I mean, this one sums it up. How weak was the prosecution case? The prosecutor tried to link Kyle Rittenhouse and his self-defense claim. With playing Call of Duty, I kid you not, this is a thing that happened in real life in a courtroom. Did this lawyer get his degree from a Cracker Jack box? Like, did he just mail in a bunch of box tops and they sent him a lawyer's degree? Honest to God, I want to know where he went to law school, because he apparently went to law school at like the Fisher-Price School of Law or something. Here we go.
Isn't it true when you would hang out with Dominic Black, you'd play Call of Duty and other first-person shooter video games?
Sometimes.
And those are games in which you use weapons like AR-15s to pretty much shoot anybody who comes at you, correct?
It's a video game where two players are playing together. I don't really understand the meaning of your question, to be honest.
Isn't one of the things people do in these video games try and kill everyone else with your guns?
Yeah, in the video game, it's just a video game. It's not real life.
So I love that Kyle Rittenhouse now has to explain to him that video games are not real life. Well done here, sir. Well done. And the University of Michigan Law School should be extraordinarily proud. By the way, Binger ran as a Democratic candidate for the position of district attorney in Racine County and was appointed Kenosha County DA about 18 months ago. Just really well done here. So the media are now reacting to this with their usual aplomb. They're attacking the judge. So when the media aren't attacking Kyle Rittenhouse for the great sin of crying on the stand, while he's on trial for murder in a clear self-defense case, they're very upset about that. And Steven Schroeder, I thought, made an excellent point about this. The same people who will tell you that it should be verboten in American life to call people by their biological pronouns because it might hurt their feelings are the exact same people who are laughing at Kyle Rittenhouse for crying on the stand in a murder trial where he's being wrongly accused of murder. Yeah, these people are not great people. Not great, Bob. Okay, so the media have now taken a new tack. The new tack is that the judge is real bad. That's the new tack. The judge is a bad meanie who's bad. According to the New York Times, the judge who has clashed with prosecutors has been in this business for 50 years. That's according to the New York Times piece. They have a long piece about this. Bruce Schroeder, the longest-serving circuit judge in Wisconsin, is presiding over the homicide trial of Kyle Rittenhouse. At times during Rittenhouse's testimony on Wednesday, he took a strict line with prosecutors, clashing with them over a reference to Rittenhouse's silence in the months before the trial and an attempt to introduce testimony on a previous incident the judge had ruled inadmissible. Judge Schroeder, 75, who has said he believes he has seen more homicide trials than any other judge in the state, graduated from Marquette Law School in 1970, worked as a prosecutor, and began serving as a circuit judge in 1983. His longevity is a subject of frequent conversation in the courtroom. In Kenosha legal circles, Judge Schroeder has a reputation for strictness in sentencing. He's known for delivering lectures to prospective jurors about their civic duty, which in this trial he likened to serving as an American soldier in Vietnam. He frequently complains about media bias and the impact news coverage can have on prospective jurors. As Judge Schroeder quizzed prospective jurors, he said he has read news articles on the Rittenhouse case, has asked himself whether he was in the same courtroom that was described in the articles. He has also acknowledged that some of the topics raised in pretrial hearings are new to him. Until this case, Judge Schroeder said in a hearing he'd never heard of the Proud Boys. The first time I saw it, or a version of it, was Chef Boyardee on a can of spaghetti because of the OK hand signal is what he's talking about. In one of the judge's highest profile cases, the 2008 murder trial of Mark Jensen, who was accused of poisoning his wife with antifreeze and smothering her, a conviction was overturned when appellate courts and the state Supreme Court ruled that Schroeder had improperly allowed evidence in the trial. The judge allowed the prosecution to present a letter that Julie Jensen had written and given to a neighbor, as well as a voicemail message she left for a police officer suggesting if anything happened to her, her husband would be responsible. So in other words, the only case that they can find on this judge that was overturned is because he was too favorable to the prosecution. But apparently this means he's very bad. The judge is so the New York Times is going after the judge. You got the Washington Post saying, as Kyle Rittenhouse trial nears end, judges' decisions from the bench come under scrutiny. Regardless of how he is viewed, Judge Bruce Schroeder is indisputably a man with fixed rules for how trials in his Kenosha County courtroom will be run. Some are basic, some unorthodox. All reflect the experience of a jurist who believes trials can be too easily manipulated, particularly by the prosecution. For a jury trial, if you get him, you're happy as a defense attorney, said Michael Cicchini, a criminal defense lawyer in Kenosha, Wisconsin. He's appeared before Schroeder numerous times, including earlier this year. In that case, he won an acquittal for his client, who was charged with battery. Schroeder's reputation has some in Kenosha worried. The 75-year-old judge is running the trial of Kyle Rittenhouse. The defense has already logged some wins in Schroeder's courtroom. Gage Grosskreutz, the man who survived Rittenhouse's gunfire, took the witness stand for the prosecution, but acknowledged he was pointing his gun at Rittenhouse when the teenager fired at him. Then, as the prosecution rested its case, Schroeder dismissed a charge for his alleged failure to comply with curfew. The judge said he agreed with defense attorneys the prosecution had not entered sufficient evidence to prove a curfew was even in effect. And then he got sharp with the prosecutor. It seems like he's aiming to let this man out of his courtroom scot-free. We're not going to let that happen, said Justin Blake, whose nephew Jacob Blake was shot by the police last year, triggering nights of unrest. By the way, if he's friendly to the defense, I'm finding it kind of hysterical that the same people who are all in on defending career criminals are like, yeah, but we can't have a judge who's pro-defense. That'd be scary. So in other words, exactly the kind of judge you would be looking for if Jacob Blake was on trial and you were an ally of Jacob Blake, you don't want for Rittenhouse. I've noticed a slight difference in how you're treating prospective criminal cases. I've just noticed. So basically, he's too liberal. He's too liberal is the rap against him. So now that's bad, according to the Washington Post. He's too liberal with defendants. I'm again getting the impression that the media are mostly interested in a verdict that they like. According to the Washington Post, while generally respected, Schroeder is not universally loved and has been accused of overstepping his authority. He once ordered a woman convicted of shoplifting to inform an employee of any retail store she entered she was under supervision for her theft. In another case from the 1980s, Schroeder ordered a babysitter accused of molesting a child to submit to an AIDS test. He began requiring sex workers who appeared before him to do the same. There's no statutory authority for him to do that, but he's been on the cutting edge of a lot of cases. Wow, what a terrible man. What a terrible, horrible man. Clearly, he will be to blame if the prosecutor brought a crappy case and the media went completely over its skis in order to push a false narrative about what was happening in Kenosha and used Kyle Rittenhouse as their case in point to prove American white supremacy. For a white guy who shot a bunch of other white guys. Really, genius stuff. Again, faith in institutions has been shaken here, and it should be shaken. And I would recommend that everybody take the same attitude when it comes to these criminal trials as we should all be taking, I think, which is wait to see how the evidence shakes out before you immediately assume the institutions are doing their job, because of late, they have not been. We're in a battle for the culture and for our values. Like and subscribe to help keep our videos on the front line of the fight and top of your feed.